My name is Jade Morrison. I'm 33 years old, and I run a digital marketing agency in Houston, Texas. Out of an office I signed the lease on myself, with a team I built from scratch, and a client list that took 4 years of 7-day weeks to earn. I want to tell you about the morning I walked into a federal courtroom and sat down across from a man who had spent 14 months trying to destroy everything I built. He had a lawsuit. He had attorneys. He had a smirk that communicated something very specific. The smirk of someone who believed the process itself was the punishment and who was enjoying watching me go through it. He had one thing he did not have: the real contract. His attorneys had submitted a version of a licensing agreement to the court that supported his claim. My attorney submitted a different version of the same document. The judge took one look at both documents, looked at the metadata, looked at the creation timestamps, and looked at my competitor across the table. The smirk came off his face in about 4 seconds. By the time the day was over, the judge had not only dismissed his $1 million claim, she had ordered him to pay me. I'm going to tell you everything. From the beginning, from where I grew up, from what I was building and why it threatened him enough to do what he did, and from the exact moment in that courtroom when the real document hit the table and the whole room understood what it was looking at. Hit that like button right now, subscribe to this channel, ring that notification bell, and stay with me through every section of this story. Because the ending is exactly what you think it is and better. I grew up in 3rd Ward, Houston, in a house where my grandmother, Me Morrison, ran her hair salon out of the back 2 rooms for 31 years. Not a big salon, 4 chairs, walk-ins welcome. The specific smell of a working salon, relaxer and coffee, and the aerosol that she used to finish every style, is so deeply coded into my memory of childhood that it still hits me sometimes in unexpected places and takes me back to sitting on a stool behind the reception counter doing homework while she worked. What I absorbed watching my grandmother run that salon was not glamour. It was the mechanics of a small business running correctly. She knew which clients came every 2 weeks versus every month. She knew who was going to refer someone and who was going to complain. She kept a notebook with every client's preferences, allergies, and last appointment. She managed her inventory down to the last bottle, and she negotiated with her suppliers with the calm precision of someone who had done it long enough to know exactly what the fair price was, and exactly what she was not going to pay above it. I never thought of that as a business education at the time. Looking back, it was the most useful education I received. My mother worked in corporate communications at an energy company downtown. She was the person who made sure the company's messaging was consistent, clear, and protected the brand in situations where the wrong word in a press release could move stock prices. She did not talk about her work at dinner in the way that made it feel impressive. She talked about it the way skilled people talked about skilled work, specifically, with attention to the details that mattered and without fanfare about the level of competence it required. Between my grandmother's salon and my mother's career, I grew up understanding 2 things that most business schools teach separately, but that actually belong together: how to build relationships with real people at the ground level, and how to protect a brand at the institutional level. I went to the University of Houston on academic scholarship, studied communications, interned at 2 agencies during school, and graduated in 2015 into a junior copywriter role at a mid-size Houston marketing firm. I stayed there 3 years and learned what I needed to learn, which was how the machine worked from the inside. And then I left and started Morrison Creative Group in 2018 with $8,000 in savings, and 1 client I had developed independently who had agreed to follow me when I went out on my own. That first client was a small restaurant group in Montrose. I handled their social media, their email marketing, their event promotion. Simple work done well. They referred me to another restaurant. That restaurant referred me to a boutique hotel. The boutique hotel was in the same hospitality network as a regional event production company. The event production company had relationships with 6 other brands. Morrison Creative Group grew by referral for 2 straight years. Not because I had a sales team or a cold outreach program, Because I delivered work that was better than what clients had been getting, and they told people. By 2020, I had 11 clients and a revenue run rate that let me hire my first employee, a designer named Priya who had been freelancing for 3 years and who became, within 6 months, so central to what we built that I adjusted her compensation structure to reflect what she actually contributed. By 2022, I had 24 clients and a team of 6 and a specific niche that had become our competitive advantage, which was brand strategy and content marketing for lifestyle and hospitality businesses in Houston and the surrounding Texas market. We were not the biggest agency in Houston. We were the best in our specific lane, and the clients in that lane knew it. This is where Derek Calloway enters the story. Derek ran an agency called Calloway Marketing Partners out of a nicer office than mine. He had been in the market for 8 years when I started, and had the head start that 8 years of being in a market provided. He was well connected in the Houston hospitality and lifestyle sector. His client list overlapped with mine at several points. We existed in the same market, serving the same general client category, with methodologies that were different enough that a sophisticated client could tell the difference and similar enough that a less sophisticated client might not immediately know who to choose. For the first 2 years of Morrison Creative Group's operation, Derek and I had a professional relationship that I would describe as cordial distance. We saw each other at industry events. We had the specific conversation of 2 professionals in adjacent competitive territory who acknowledged each other without engaging deeply. In 2021, that changed. Morrison Creative Group won a contract that Derek had pitched for. A hotel group with 4 properties in the Houston area that was looking for a brand refresh and a content strategy for their expansion into a 5th property. The contract was significant, multi-year, substantial monthly retainer, the kind of anchor client that changed what you could build. I know I won it over Derek because the hotel group's director of marketing told me directly, in our first kickoff meeting, that our strategic proposal had been more specific and more aligned with where they were trying to go. Derek found out he had lost the contract within the week. The Houston hospitality industry was small enough that news moved. I did not hear from him directly. What I heard, over the following months, was from clients who mentioned that they had received outreach from Calloway Marketing Partners that included unfavorable references to Morrison Creative Group's size and experience level and capacity to handle complex accounts. The references were carefully worded, not defamatory in the simple sense, but the kind of language designed to plant a question in a potential client's mind about whether a smaller agency could deliver what a larger one could. This happened 3 times across 6 months. I noted it. I did not respond to it publicly. I let the work respond. Then, in late 2022, Derek proposed a collaboration. Derek reached out through a mutual industry contact with a proposition. He said there was a major campaign coming up, a Houston tourism initiative backed by partial public funding that required an agency with specific credentials in both digital marketing and event production. His firm had the event production experience and the city relationships. Morrison Creative Group had the digital marketing and content strategy capability that the campaign's digital component required. He was proposing a joint bid, co-led by both agencies, with defined scopes of work for each. The proposition had logic in it. The campaign was real. The public funding attached to it was real. The credential requirements were specific enough that neither agency could bid as compellingly alone as we could bid together. I was cautious. My attorney, Rachel Nguyen, had been handling Morrison Creative Group's legal matters since year 1. She was 37, had been practicing business and IP law in Houston for 9 years, and had the specific quality of someone who was very calm and very smart, and who had seen enough versions of collaboration gone wrong to read proposals carefully before recommending them. She read Derek's proposed collaboration agreement carefully. She came back with 17 revision requests. The most significant revision request was about the IP ownership of the work product created during the campaign. Derek's initial draft had a clause that was, in Rachel's words, deliberately ambiguous about whether jointly created strategic materials belonged to both parties, to neither party, or were transferable. She said the ambiguity was not accidental. She said it was the kind of language that was designed to look inclusive while preserving the ability to claim ownership later if the relationship became adversarial. I told her to revise it to be unambiguous. The revised agreement, the one that Rachel drafted and that both parties signed, was explicit. All strategic materials, brand frameworks, content systems, and campaign architectures developed during the collaboration were jointly owned for the purposes of the specific campaign and exclusively owned by their originating agency for any use beyond the campaign. Morrison Creative Group's contributions were Morrison Creative Group's. Callaway's contributions were Callaway's. We signed the agreement in February 2023. The campaign ran successfully from March through September. It produced measurable outcomes that both agencies included in their portfolios. The working relationship was functional without being warm. Derek and I were professionals executing a defined scope of work, and I was aware the whole time that the relationship's cordiality was contingent on the outcomes serving both parties. In October 2023, Morrison Creative Group won a second significant contract. A regional retail brand looking to expand into the Texas market and needing a comprehensive brand strategy and digital marketing system. The work we did on their campaign incorporated frameworks and strategic approaches that I had been developing and refining across 5 years of working in this specific market. In December 2023, Derek's attorney sent Rachel a letter claiming that the retail brand campaign's strategic framework was derived from work product created during the collaboration, and that Morrison Creative Group's use of it constituted a breach of the collaboration agreement and misappropriation of intellectual property. The letter demanded $1 million in damages. Rachel read the letter and called me. She said, "He's attaching a version of the collaboration agreement to the letter. The version he's attached is not the version we signed." I said, "What version is it?" She said, "It's a version that does not include the exclusivity and origination clause we negotiated in the 17 revisions. It's the original draft, his original draft." I said, "Rachel." She said, "I have the signed version with the metadata intact from the day of signing. I have the 17 revision emails. I have my own drafting history. I have everything." I said, "He submitted a version of the contract that doesn't include the revisions." She said, "He submitted what he is apparently claiming is the governing document." She was quiet for a moment. Then she said, "This was a mistake on his part that is going to be very expensive for him." Derek filed the lawsuit in January 2024. I want to tell you what a lawsuit like this actually feels like from the inside, because the version of it that ends with the judge ordering your opponent to pay you is only the final frame of a much longer film that has a great deal of difficult content. The filing itself was public record. In Houston's business community, public record moved fast. Within 2 weeks of the filing, I had received 3 calls from existing clients who had seen mention of it online and who wanted to understand what was happening. 2 of them were reassured by my explanation and the conversation. One of them paused a contract renewal while they evaluated the situation. That paused renewal cost Morrison Creative Group 3 months of revenue from that client. Derek knew what a lawsuit did to a small business's relationships even before it went to court. A filing that said Morrison Creative Group misappropriated intellectual property in its headline, regardless of whether the claim was true, regardless of whether the documentation supported it, planted exactly the question he had been trying to plant with the unfavorable references 2 years earlier, except now it was in a legal document with a dollar amount attached. That was the strategy. Rachel explained it to me in our first full litigation strategy session. She said, "He doesn't expect to win $1 million. He may not expect to win at all. What a lawsuit of this type does is force you to spend money defending it. Distract your attention from building your business, create uncertainty in your client relationships, and produce a public narrative about your company that he can reference regardless of how it ends." She said, The document he submitted is going to be the thing that ends this. But we have to get to the courtroom first, and getting there costs time and money. She was right on both counts. The 14 months between the filing and the court date cost Morrison Creative Group approximately $68,000 in legal fees. It cost me time I cannot calculate precisely, because the time it took was woven through every week of those 14 months. The calls with Rachel, the document reviews, the depositions, the preparation sessions, the mental space it occupied even in the hours when I was not actively engaged with it. Priya asked me once in the 9th month whether I was okay. Not about the lawsuit about me, whether I was sleeping, whether I was eating correctly, whether the thing was getting inside my head in the way that sustained stress got inside people's heads and changed how they operated. I told her I was managing it. She gave me the specific look of someone who had known me for 4 years and who knew exactly what managing it looked like from the outside. I was managing it. I was also tired in a specific way that was different from the tired of hard work, which I had always been fine with. This was the tired of having energy spent on something that produced nothing, the tired of defending rather than building, of being forced to prove a negative, of watching the calendar move toward a court date, while the days that should have been building something were spent in review and preparation, and the particular sustained vigilance of someone who understood that the documentation had to be perfect because the other side was counting on imperfection. The depositions were the most revealing part of the pretrial process. Derek's attorneys deposed me for 4 hours. They asked about the collaboration, about the retail brand campaign, about my creative process, about the specific strategic frameworks I had used. The questions were designed to establish a narrative that the retail campaign's approach was derivative of the collaboration's work. The questions were specific, and some of them were genuinely sophisticated. I answered every one of them accurately, and completely because accuracy was on my side, and the truth, told clearly and consistently, was exactly what I needed the record to contain. When Rachel deposed Derek, the session lasted 6 hours. She told me afterward that the deposition had gone the way she had expected it to go, which was that Derek had maintained his narrative about the contract version he had submitted while being unable to explain, specifically and on the record, why the signed version, the one with the revised language, contained clauses that his submitted version did not, and why those clauses had been removed in the version he had attached to his claim. She said he could not give a coherent explanation for the discrepancy. I said, because there is no coherent explanation. She said, exactly, but I wanted it on the record so the judge sees that it was tested and could not be explained. The court date was set for March of the following year. I spent the 3 weeks before it working normal hours and not doing the thing I had seen people do before high-stakes situations, which was over-prepare to the point of exhausting yourself before the event started. Rachel had everything she needed. The documentation was complete. The metadata was intact. The revision email chain was organized chronologically and clearly. The 17 revision requests were documented in Rachel's own files from the day she sent them. There was nothing left to prepare. There was only the showing up. The courtroom was in the federal building on Rusk Street in downtown Houston, 14th floor. The kind of room that had a specific quality of institutional seriousness. The wood paneling, the elevated bench, the gallery behind the bar, the way the acoustics made every voice carry with a weight that ordinary rooms did not produce. Derek arrived with 2 attorneys. He was dressed in a suit that communicated the specific message of a man who had decided his presentation mattered. He sat at the plaintiff's table. When we made eye contact across the room, he held the contact for a moment with the expression that I described in the beginning, the smirk. The expression of someone who believed the process itself was the punishment. I sat at the defendant's table with Rachel. She had a single folder. She had told me in our final prep session the day before that she had reduced the entire documentation to 1 folder. The signed agreement, the metadata printout showing the creation and modification timestamps, the 17 revision emails in sequence, and a 1-page timeline she had prepared showing exactly how the document had evolved from Derek's original draft through each of the 17 revisions to the final signed version. She said, "Everything the judge needs is in this folder. I am not going to overwhelm the court with volume. I am going to give them exactly what they need to see in exactly the order they need to see it." Derek's attorneys presented their case first. The presentation was smooth and well-prepared. They submitted their version of the collaboration agreement. They argued that the retail brand campaign's strategic framework was derivative of work product created during the collaboration. They referenced specific elements of the campaign that they claimed were traceable to the collaboration's joint output. The argument had a structure. It was not a ridiculous argument on its face. But it depended entirely on the version of the contract they had submitted. The version that was not the signed version. Rachel stood when it was time to respond. She said, "Your Honor, I'd like to submit what I am representing is the executed collaboration agreement between Morrison Creative Group and Callaway Marketing Partners, bearing both parties' signatures, along with the document's metadata and the email correspondence documenting the revisions that produced the executed version." She opened her folder. She approached the bench. She laid the documents down. The judge, the Honorable Patricia Watkins, who had been on the federal bench for 11 years and who had, based on everything I had observed in the preceding 2 hours, exactly zero tolerance for anything that wasted her time, looked at the documents Rachel placed before her. She looked at the version Derek's attorneys had submitted. She looked at the version Rachel had submitted. She looked at the metadata. She looked at the revision email chain. This took approximately 4 minutes. Then she looked at Derek. This is the moment I want to describe carefully, because it was the specific 4 seconds that I had spent 14 months and $68,000 arriving at, and I want to describe it the way it actually happened, rather than the way it sounds in a summary. The judge looked at Derek at the plaintiff's table, and her expression was the expression of a federal judge who had just confirmed something she had suspected, and who had decided how she felt about it, and who had no interest in taking additional time to express that feeling at length. She said, "Counsel, can you explain the discrepancy between the documents submitted as Plaintiff's Exhibit A and the executed agreement provided by the defense, specifically the absence in Plaintiff's Exhibit A of the exclusivity and origination clause contained in Section 4 of the executed agreement?" Derek's attorney said, "Your Honor, we believe." The judge said, "I'm asking specifically about the absence of the clause, not about your interpretation of it. The clause is not in the document you submitted. It is in the signed agreement. Can you explain how that discrepancy occurred?" There was a pause. Derek leaned toward his attorney and said something quietly. His attorney said, "Your Honor, we may need a brief recess to review." The judge said, "I'll give you 10 minutes. The 10 minutes produced nothing that improved Derek's position. When the proceedings resumed, the judge did not take long. She said, "The court finds that the document submitted by the plaintiff as the governing agreement does not match the executed agreement on file with the defendant's counsel, which bears both parties' signatures and which contains provisions materially relevant to the claims at issue. The executed agreement's terms do not support the plaintiff's claim of misappropriation as presented. The claim is dismissed." She looked at Rachel. She said, "Counsel for the defense, you've indicated a counterclaim." Rachel said, "Yes, Your Honor, for the legal costs associated with defending a claim that the plaintiff's own execution records demonstrate was unsupported by the governing document." The judge said, "The court finds the counterclaim meritorious. Mr. Callaway, your firm will pay Morrison Creative Group's documented legal costs in this matter." She said the number. The number was $68,412. She closed her folder. She stood. The bailiff said, "All rise." Derek Callaway's attorneys filed a notice of appeal within the standard window. The appeal went nowhere. Rachel had expected this and had told me not to let it bother me because an appeal filed without new evidence or a specific legal error to cite was primarily a delay mechanism rather than a genuine challenge, and the court confirmed that assessment within 5 months. The $68,000 arrived in a wire transfer 7 months after the judgment. I took the whole team to dinner. Not a celebration dinner in the dramatic sense, just dinner, at a restaurant that had been a client of ours for 2 years, where the food was excellent, and where the team that had held Morrison Creative Group together through 14 months of this sat around a table and talked about something other than the lawsuit for the first time in what felt like a very long time. Priya gave a toast. She said, to building something real and knowing what it is. I thought that was exactly right. The aftermath of the case in the Houston marketing industry had the specific quality of aftermath in small professional communities, which was that people knew what had happened and drew their own conclusions, and the conclusions were not favorable to Derek. 3 of his clients reached out to Morrison Creative Group in the 18 months after the judgment, not because of the lawsuit directly, but because the reputation that the lawsuit's outcome had built, combined with the reputation the work had been building for 4 years, created a specific picture of what Morrison Creative Group was. The paused contract renewal that I mentioned, the client who had held off during the litigation, they renewed in the month after the judgment. Their director of operations sent me a note that said, "We watched how you handled it. That told us what we needed to know." I have thought about that note a great deal. What they were watching, across 14 months, was whether I kept building while the lawsuit was happening, whether I showed up for my clients, whether Morrison Creative Group's work got worse or better or stayed the same during a period that would have justified getting worse, whether I let the distraction become the story or kept the work the story. The work stayed the story. Not because I was not affected by the lawsuit. I was, significantly. But because the day I stopped building was the day Derek's strategy worked regardless of how the legal case ended, and I was not going to let that happen. Rachel and I had dinner 2 months after the settlement arrived. She said, "There is a specific lesson in this for every small business owner who is watching someone else have this experience." I said, "What is it?" She said, "The contract you negotiate before you need it is the only contract that protects you. The version Derek submitted was his original draft. The version that protected you was the one we spent 3 weeks revising before you signed. Every one of those 17 revisions was a potential failure point that we closed before it could be used against you." She said, "Most business owners sign the first draft." I said, "Why?" She said, "Because the relationship feels good at signing time, and the revisions feel like distrust. Like you're planning for the relationship to fail before it starts." I said, "My grandmother used to say that a handshake was for people you already know, and a contract was for people you want to keep knowing." Rachel said, "Your grandmother was a business attorney in a previous life." I said, "She ran a hair salon for 31 years. Same thing, different product." Morrison Creative Group is now in its 6th year, 29 active clients, a team of 9, an office in the Midtown Houston area that I signed a 3-year lease on last spring. The client list includes 2 clients who came from Callaway Marketing Partners, not because I sought them out, because they found us. I do not think about Derek Callaway very often, not because I have performed some deliberate letting go of what he did, because the bandwidth that thinking about Derek would require is bandwidth I am spending on the work, and the work has always been the better use of it. The folder that Rachel assembled for the courtroom, the signed agreement, the metadata, the 17 revision emails, the 1-page timeline, lives in a physical binder in the filing cabinet in my office, not as a trophy. As a reminder of what documentation looks like when it is complete and what it can do when you need it. I have not signed a collaboration agreement since that one without Rachel reviewing it first. I will not. I'm Jade Morrison, 33 years old, Houston, Texas. The thing I want to leave you with is not the courtroom moment, even though I know that is the part of the story that feels the most satisfying, and that is the most satisfying to have lived. The thing I want to leave you with is the 17 revision requests. Because the courtroom moment only happened because of those 17 revision requests. Because Rachel sat with that contract for a week before I signed it, and identified every place where the language could be used against me later, and revised each one into something that said what it meant and meant what it said. Because I trusted her judgment enough to let the process take 3 weeks instead of 3 days, even when the collaboration opportunity felt time-sensitive. The signed contract that went to the courtroom was the result of 3 weeks of careful work before the relationship started. The document Derek submitted was the document he had hoped I would sign before the 3 weeks happened. He was counting on impatience, on the pressure of an opportunity, on the fact that most people, when a deal is in front of them and the relationship feels good, do not want to introduce friction by asking for 17 revisions. Be the person who asks for 17 revisions. Find your Rachel Nguyen before you need her and involve her in every agreement before you sign it. Not after something goes wrong, before anything goes wrong. Because the contract you negotiate in the good moment is the only one that protects you in the bad one. That is the whole lesson. Everything else is just what the lesson cost. Hit that like button if this story hit something real for you today. Subscribe to this channel. Every story here is this complete and this honest. Share this with a business owner in your life who is about to sign something without having someone like Rachel look at it first. Ring the bell. Build something real. Protect it before you need to. See you next time.